Next speaker, a sleeper, because he's not the one that necessarily blows you over with a lot of burst of energy from the podium about his message, but he knows what he's talking about. He's more of a laid back but very effective individual, and he's been in the freedom movement for a long time. In fact, this gentleman from Tulsa, Oklahoma, became a member of National Commodity and Barter Exchange way back in 1980. So that's almost 20 years, folks. This guy's been in the movement. And he was a press secretary for Mr. John Grambush, who was running in 1982 as a governor candidate of the state of Colorado. This gentleman is also an elected city councilman again back there. And he's a member of the Freeman Education Association and Free Enterprise Society, works closely with them. He works and cooperates closely also with Freedom Law School, has had very good input in some of the things that we're doing and we're saying these days. He was one of the plaintiffs, or I think the plaintiff, in the case of Pleasant Lovell versus Bivens. This was one of the very first cases where a civil rights suit for violation of our civil rights was done by freedom lovers against IRS agents. And you know what? Those cases, vast majority of them are just dismissed before they ever get to trial. Well, this one got to trial. Didn't win, but at least they went that far. So this person has a lot of experience as far as what do you do when you get to court with the IRS, and how do you go after them? What can you do? What you cannot do? He has a lot of things to share, not enough time, but I've asked him to share with you, amongst other subjects he's going to be sharing with you, about how to get a copy of your records from the government. You know what those snoops are up to, so you can use that information in your favor now. So please, help me give a warm hand of welcome to our next speaker from Tulsa, Oklahoma, Mr. Brough.
I got magic for you! Everybody, magic! Who needs magic today? We all need some magic, don't we? We need to change something that's going on. I brought the magic.
You got magic?
I brought the magic.
And silver bullets.
Oh! I didn't bring the silver bullets.
Ah, shucks.
Just magic. Good for you. Good for you. Good for you. How is everyone this morning? I got a lot of equipment up here. Can you hear me okay? Okay, that's good. What? Payman, what are you telling people I'm a sleeper for? I don't know what that's about. Not sure he does either. He didn't apologize either for what he said last night. When I wasn't here, I was actually trying to make a phone call and get in touch with my family. So, and I was also making another important call. Steve Hempfling said to grab a Constitution. Last night, I was able to get through to the United States Supreme Court and check with them to find out what it is that is still in our Constitution. And after talking with Chief Justice Wrenchberg, I made a few notes on the Constitution. He was able to tell me that other than a few things that have been struck out, still remaining is "we the" and "do ordain and establish." Otherwise, things are just fine. So you can go ahead and mark up your Constitution right now. Bring it all the way up to date. See, there's a whole bunch of people who missed out this morning, and I knew that was going to happen. You never know what you're going to get this early in the day. Of course, y'all know this one, right? The difference between an IRS agent and a tick. Yeah, that's right. A tick falls off when you die. Of course, you've also heard of the IRS creed, right? Everybody knows that one? A man is innocent until proven broke. Maybe I should slow that one down. You know, it's kind of creeping through. A man is innocent. I'm doing this in Oklahoma way. Y'all, a man is innocent until proven broke. See, it still creeps through the audience. Now, last night I was accused of having an amber beverage when an award was handed out to me, and that wasn't so. However, later in the evening I was able to do some research, and we discovered exactly what the oath was that Bill Clinton swore to. I'd just like to cover that with you. I swear to lie about the truth, the whole truth, and nothing but the truth. And that's what he said when he took his deposition. It was funnier when we did the research. You know, and then yesterday, is Shelley Davis here this morning? Yeah, she's here. This one's for you. I had to struggle with the part where you said you were struggling to get into the White House. I said, come on, girl, it's Bill Clinton. What are you thinking? I had given her more credit than that.
You couldn't stop talking long enough.
Okay. If I can read my notes here. I actually made an outline. Stuck it on the back of an envelope. I've been around this freedom movement for quite a while. I've seen a lot of things come and go. My topic for you today is the Freedom of Information Act. It's a particular favorite of mine because it's right up there with the National Enquirer. Inquiring minds want to know. And if there's something you want to know, there's not a better tool that you can use. I came to this movement really through NCBA, and I read Irwin Schiff's material. I discovered the light, if you will, and I took off like a rocket. I had the great fortune to work with people from the National Commodity and Barter Association, Jerry Manka and John Pleasant. Some of you have been around a while, probably know those names. They kind of set me off on a path, taught me how to do legal research, and they put me up to challenging a law in Colorado early on that permitted me to set a record with the most number of parking tickets issued by the city and county of Denver. And I challenged parking tickets constantly. I had a record for having 54 of them dismissed in one setting. It's a little tricky, but that was low-risk litigation. Okay, it's a good place to learn. Now, how much trouble are you going to get into with parking tickets? I mean, it's like, what are they going to do, take away your birthday? But what you're going to do when you find low-risk litigation is you're going to get an opportunity to go into the courthouse. You're going to get an opportunity to play with some of these people. You're going to get a chance to meet the judges. You're going to get a chance to learn about the rules. You're going to get a chance to meet the prosecutor, and get a sense of how that system is going to work. I can just about assure you that if you're going to stay in this movement for a while, you're going to get involved in some kind of litigation. one form or another. One of the forms of fairly low-risk litigation is the Freedom of Information Act. I call it the only lawsuit you're guaranteed to lose and still get paid. And I'll explain that as part of this presentation. What brought me to the Freedom of Information Act was in 1983. I grew up in a small town in Colorado, high in the mountains, called Estes Park, set on the outskirts of Rocky Mountain National Park. In 1983, a high mountain lake dam failed and flooded the community. My family owned a market in Estes Park, and that market was flooded. I went up to help my family straighten that out. While I was doing that, and we're mucking out after a flood, some of you have probably been involved in that in one form or another, I got to thinking somebody had to be responsible for what had occurred. Now this lake, the dam, was on the property of the Rocky Mountain National Park, part of the Department of Interior. After I thought about it for a while, I contacted John Pleasant. I said, John, somebody's got to be responsible for what's occurred. And John said, well, maybe you want to do a Freedom of Information Act request and inquire into the Park Service about what they know. And I said, great, sounds like a great idea. How do I do it? And over the telephone, John set out for me a few things that I had to say in order to perfect a request to the Park Service. I made that request about 4 days after the occurrence of this flood. The Park Service released about 600 pages to me about 2 weeks later. 3 weeks later, litigation was instituted against the Park Service and the owners of this dam and mountain lake and the water rights that existed there. And the Park Service shut off the flow of information. I was the only person who had the information out of the government about what they knew about that lake. Well, what they knew was that the dam had been added onto without a proper permit, that there had been inspections, the owners were on notice about certain problems, and nothing had been done about it. Also contained in that release were transcripts that were redacted or sanitized. If I say the word redaction, I'm talking about marking out portions of the information. Those transcripts were the testimony of individuals who were in the area of the dam and the drainage that was flooded. They were chilling descriptions of the event itself, as well as descriptions of the loss of life that occurred in that event. But that was the only release that was made by the Park Service. Those documents were eventually turned over to the attorneys in litigation. That particular round of litigation lasted about 15 years and was ultimately settled with the water rights being given to the people who were injured. Just so that you know, the Park Service, being our friends and here to help us, determined that those water rights were not transferable since they originated on government property and prevented the people who received the water rights from making any transfers. And as of this date, those transfers haven't been made. No transfers have been made of those water rights, and that was from an event that happened in 1983. Just as a side note, Payman mentioned that I was a plaintiff in a lawsuit called Pleasant v. Lovell. Pleasant v. Lovell was a Bivens lawsuit. The lead plaintiff was John Pleasant. It was filed initially by 435 NCBA members against 17 IRS agents who engaged in an illegal search and seizure of the NCBA headquarters. That lawsuit went to the appellate court 3 times, ultimately to the Supreme Court. The appellate court on the second trip held that the IRS agents involved in that, after it had kind of been whittled down to about 3 of them, would have to stand trial for what they did. It was the first time that IRS agents had been held to trial in a Bivens-type lawsuit. It doesn't happen very often. It's very difficult to do, but the report is that it's possible. The plaintiffs in Pleasant v. Lovell ultimately lost the litigation. The judge determined that the lady, one Pauline Adams, who had been rejected by the FBI as an uncredible witness and prone to fabricate, who had undergone 16 electroshock therapy treatments, that the ATF had found not credible was good enough to be an undercover agent for the IRS. She was sent into the headquarters of the NCBA to gather trash which contained the names of certain members of the association. When it was discovered that she was acting as an undercover agent, members of the IRS and Miss Adams were sued. The court ultimately held that Miss Adams was not an agent of the government. So there's a couple of footnotes on kind of what we're dealing with in terms of challenges with the government. Let's talk about FOIA for just a minute. Everybody knows who Christopher Columbus was, right? He was considered to be a great discoverer. He went out looking for something. What did Chris think he was looking for? Chris thought he was finding a shortcut over to the Indies so he could bring back spices. What did he find? He found something completely different than what he was looking for. If you will treat your exploration into the government as a trip of discovery, you may start with an idea that you're looking for something in particular, only to find out that you're getting something completely different. The question is, can we sort out what is treasure and what is trash? A lot of what you might get on the surface would appear to be trash, but it's actually disguised as treasure. People in the freedom movement, the tax movement, Patriot movement have been trying to help you decipher a lot of that for quite a period of time. You can make headway on your own. I would tell you that I'm able to stand up here and tell you about some things, not because I'm particularly remarkable, but because you have shared with me over time. Frankly, you've taught me more than I've been able to teach you. So I want to encourage you, as you engage in an exploration of government, when you find something that you think is interesting, to let people know. Let Payman know. Let Vern know. Let Bill Benson know. Report in what you've discovered. You may not know initially what you've gotten your hands on, but if you engage in an exploration, in discovery, we will find all kinds of treasures that have yet to really be uncovered. I'm going to give you a couple of book titles. Those of you who have pencils sharp, you'll probably want to write these down. I have a bad habit with these sticky flags. When I read something, I mark it up so that I can find what was important. Turns out, in a book like this, I mark up a lot of stuff. This book is the IRS and the Freedom of Information and Privacy Acts of 1974. That title again, it's the IRS and the Freedom of Information and Privacy Acts of 1974. It's written by a man by the name of Marcus Farbenblum. Marcus Farbenblum. That's F-A-R-B-E-N-B-L-U-M. And I'm not handing you this information just to entertain myself, but some of you will want to get this book. It's available from McFarland and Company, Jefferson, North Carolina. Let's see if I can get a better address than that. I think there's one here. Yeah, McFarland and Company, Publishers, Box 611. McFarland and Company, Publishers, Box 611, Jefferson, North Carolina. Just like Tom Jefferson, Jefferson, North Carolina. Zip 28640. What's significant about this book is that Marcus Farbenblum was in the Office of Chief Counsel Disclosure Litigation at the IRS. He takes the time to tell you where the bodies are buried if you'll take the time to read the book. One of the things that I found significant, and I'm going to share with you some statistics. I kind of hoped we had a little better light. Is it okay with the camera guys if I move over a little bit to the light? Hey, that's a good sound. Or maybe we don't move over to the light. Let's do it this way. These statistics come from 1986. In that year, there were 188 million tax returns filed. 85 million of those were individual income tax returns. The examination audited more than 1 million returns, and 2/3 of those resulted in additional assessments. Okay, so they audited 1,666,000 666,000 resulted in additional assessments. The collection division took action against 2.5 million taxpayers. So you're looking at 3 million people who have 3.5 million people who have interfaced with the IRS in that year. The Criminal Investigation Division completed 6,000 investigations. They obtained 2,500 convictions, most of which resulted in prison sentences, so the book says. So you've got 3.5 million people who interfaced. Does anybody want to take a shot at how many Freedom of Information Act requests were made in that year? 0? 50? There were 10,820. 10,820 Freedom of Information Act requests are made. That works out to one FOIA request for every 17,365 taxpayers. Of those 10,280 requests, and this is significant, 2,749, roughly a fourth, were so poorly constructed they could be denied as imperfect without having to locate or evaluate a record for release. So the IRS got 1/4 of those 10,000 requests and were able to stamp them denied because they didn't do the proper things to perfect the request. (1,224) requests asked for records which did not exist. So that's about 12%. Another 640 requesters asked for records concerning themselves but failed to establish their identity and didn't say who they were. I know some of you guys did that too. You know, some of you do it just for entertainment value, just to see what they'll do. Will they write me back? Well, they can't write you back if you don't put a return address down. It's secret. 5,845 requesters received a response which actually said either yes, you may have the records, or no, you may not. So about half of them got a response dealing with the records. Of the 5,845 requests that got a yes or no, we've got some records or we're not going to give you the records, 1,996 received either a full or partial denial. So almost 2,000 requesters were told, we're not going to give you what we've got. Only 3,849, slightly over a third, actually received everything they asked for. Now, those are his words, and I'll explain why that sounds silly to me in a minute. They received everything they asked for? How do they know that? Now, of those 1,900 that were denied, only 802 of those 1,900 requests were appealed. In other words, when the IRS denies you the access to the records, it's a very simple letter. In fact, they send you a notice when they deny access telling you exactly what to do. Only 802 of 2,000 people appealed the denial of access to records. Of those 802 appeals, only 21 were granted full releases. There were 65 appeals that resulted in a partial or additional release. Does anybody want to take a guess at how many lawsuits were filed that year against the IRS for failure to release records? 11. 48. 48. That means the odds against an officer of denial, a disclosure officer who denies your request, being challenged are 145 to 1. And so you wonder why you might not be getting all of your records. How does a bureaucrat get a raise? Do less work. Right? Do less work. Here comes a request. Denied. I've done less work, and I've responded. Now, if the IRS does send you the stuff, and I've heard you say it, I got everything I requested. Really? How do you know that? Were you there? Did you look? I got everything I requested. You don't know that. You have no way to know. You weren't there. If the IRS sends you back everything and you've got enough to satisfy you, you don't have to do anything. I always appeal. Why? Because I can. Because I have no way of knowing that they actually gave me everything I asked for. You want an even more entertaining piece? They mark things out. Sometimes they use a black marker like we did with the Constitution. Other times they white it out. And if they're really good, you won't notice. I always appeal. Sometimes they cut it out. Yeah, they'll take an X-Acto knife and remove it. Sometimes, and this is fun when this happens, they make a mistake and send you the originals. That's fun. Sometimes they make a mistake and send you someone else's originals. Want to make a friend with the disclosure office? Call them up and say, you know, something must have happened. You sent me John Jones's records. And you know, I think that's an unauthorized disclosure. Would you like me to send them back? And you can hear them palpitate on the phone. Oh, yes. That's a crime when they do that. That's a crime. That's a problem. You want to make friends with your disclosure officer? I'll tell you what. Disclosure is really probably the nicest guys I know at the IRS. Most of them don't really have a beef. Most of them will just give you the stuff. Sometimes they don't like the guy who's doing your case. And they'll send you the stuff just to get him. I mean, you don't know. You do not know what kind of politics you're going to run into. So request. Always request. Curiosity. Here's what Farbenblum, and understand, Farbenblum is not your friend. But here's what he has to say about the tax protest movement. And what you're dealing with, I think at least to a certain extent, when you make a request to the IRS. The tax protest movement's use of the Freedom of Information Act added to the evidence which convinced many officials that the act merely served to harass the agency and waste its resources. Prior to the appearance of the protesters, however, the service's apathy to the act was limited to the national office managers whose opposition was based upon loyalty to the service or concern about their careers. The tax protesters convinced rank-and-file employees that the Freedom of Information Act was an evil to be resisted because it interfered directly with the work they were doing and threatened the physical safety of themselves and their families. Well, this is an act that's on a piece of paper that Congress wrote, and somehow this piece of paper is threatening. Boo! I've got the Freedom of Information Act here! Boo! It always gets them. They'll run from that. And if that doesn't work, get the magic! Many of the employees were members of a generation which believed that unfair or evil laws. Now check this out. This is the IRS's lawyer here, people. These employees were members of a generation which believed that unfair or evil laws should neither be enforced nor obeyed. And we're talking about the tax protesters. Let me see if I have this right. Consequently, they frequently did whatever they could to avoid full compliance with the law. They think that turning over the information is somehow a problem. being fully disclosing in government is somehow a problem. Leaving taxpayer correspondence unanswered, destroying correspondence was completely outside the service traditions, yet the protester movement induced these types of behavior through simple device, overwhelming offices with frustrating requests. Local managers supported the behavior of their employees partially because they shared the emotions on which they were based and partially because it was easy to maintain loyalty and commitment. That's right. You got it. It's your fault. Don't ever forget, much of what goes on is in fact our fault. I don't get it, but I mean, this movement has done incredible things. And I'll digress for just a moment because I think it's important that you know this. Last year, the IRS took a beating. I believe part of that was show. Part of it was because of things you have done. And if you don't think that's true, you need to take a quick look at the history of what's occurred. When I got involved in this in the early 80s, late 70s, people like Armand Kondo and John Grandbush and others were traveling around the country suggesting that people file exempt W-2s. People filed exempt W-2s, and what happened? No withholdings. Then they changed the rules. If you went exempt W-2, they'd come after you, they'd force the employer to withhold. So people said, well, what's the best way to not have withholding? I'll become self-employed. People became self-employed. There was no reporting requirement. And then, here come the 1099s. All of that goes along with the civil disobedience of not filing, of protesting the law. That non-filing caused what I call the dolphin in the tuna net. IRS was compelled to engage in behavior that cast a net over more and more innocent people. As they did that, they created a higher and higher degree of frustration. They caught porpoise in the tuna net. And those people began to scream. That caused a big chunk of the change. 10 years ago, I don't think there's anybody here that would have suggested there would be a debate in Congress about whether or not we should be keeping the income tax. That would be part of the political process. But it's become part of our national dialogue. And I would tell you, it's because of things that you all have done. You all make a contribution to that. So yes, it is your fault. Don't forget that. If you forget, we stop making change. And without change, we're in big trouble. Back to the Freedom of Information Act, I digress. I have a book that I brought along, which is a handy-dandy little resource for those of you to be able to use. It's Freedom of Information Act letters on disc. And I got to tell you, 10 years ago, 15 years ago, you could not convince me I needed to learn to become computer literate. Today, you cannot convince me that our future will not be shaped by that equipment. If we don't get with it, and 10 years ago there were people saying, hey, we better get computer literate. If we don't get with it, we're missing a huge opportunity. The computer power gives us strength. The internet gives us strength. Email gives us strength. Don't miss that. I've put over 100 different requests on a computer disk so that you can generate your own requests. When you generate requests to the IRS for information, why, you're getting all the government you're paying for. You might as well take advantage of them. They're there. When you make a request properly, they have to respond. If they're not responding, there's things you can do. Let's touch on real quickly the things you have to do to create a Freedom of Information Act request that'll work. There's some discussion about whether one should use the Privacy Act or the Freedom of Information Act. I'm going to tell you that generally when somebody comes to me, they're in crisis. They don't come to me generally for preventive maintenance. When somebody comes to me in crisis, the result is we want information. We need information. With information, if we can collect what the IRS knows about you, and we know what you know about you, we're twice as smart as they are. Because we know everything they know, and we know everything we know. So the Freedom of Information Act is the most efficient tool to get in there and produce results. So I'm going to talk about that. The Privacy Act does give you a few benefits, but the Freedom of Information Act's broad brush gives you greater access to information. Things that you have to do. First, the request must be in writing. You cannot make a request under the Freedom of Information Act orally. You must make it in writing. You must state that it is a request under the Freedom of Information Act, 5 U.S.C. Section 552, or if you're using the Privacy Act, 5 U.S.C. 552, small a. 5 U.S.C. Section 552, that's the Freedom of Information Act. The Privacy Act is 5 U.S.C., United States Code is what that stands for, Section 552A, small a. In order for the IRS to release information about you, as I said, if we release information about you to someone else, that's a problem. You must adequately identify yourself. The most efficient way to do that is with a notary statement. Those of you here in California, that can get pretty pricey. Some of you are using a single notary statement over and over. That certainly will work. You can photocopy your passport. Those of you who have driver's licenses, you can photocopy your driver's license, and you can use 3 witnesses. Again, I will recommend a notary statement because it's efficient. It tends to work. It gets the job done. But those other alternatives will work. If the IRS comes back and challenges it, you can respond to their challenge with another letter and do the thing you always do. Appeal. 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 Even if they give you everything, appeal. How do you know you got everything? Appeal. If you don't appeal, you can't go to court. You must identify the tax years that you want information on. I recommend that you do that separately. 1991, 1992, 1993, 1994, 1995, etc. Do not go 1991 through 1999. If you do, you give them the excuse to segregate records and give you 91 and 99. Save yourself the headache. You must identify the type of requester that you are. You will be typically an other requester. Most of you are not a school, a newspaper, a scientist, or a commercial requester. I mean, you're not requesting information for purposes of reselling it and making a profit. The only category that exists for most of us is other. So you'll need to identify yourself as an other requester. Under the Freedom of Information Act, you only need to reasonably describe the records you seek. And what does that mean? That means if you can describe the record that you want, that an IRS officer can understand your description and go get the record, that's sufficient. I understand that's kind of a vague definition, but I've seen your work. You're creative. Reasonably describe the record you want. If you're looking for that substitute for return that they filed for you, why, you can ask for the substitute for return. They'll know what you're asking for. If you're looking for the document that permitted them to start contact with you in the first place, in the first instance, that might not sufficiently describe what you're seeking. Don't be afraid to try it. Don't be afraid to be experimental, because what can you do? If you don't get an answer that makes sense, appeal. I've never done a Freedom of Information lawsuit that has not produced more records. Even if it was only 1 page, we got more paper. So if you try to make a description of what you're seeking, and you appeal, and you enter into litigation, you will stand a good chance of getting the IRS to produce something, because you're going to get a chance to talk to the lawyer on the other side, and he's going to say, what are you trying to get? What are you after? And you can try again to describe it to him. He may be helpful, he may not. Ultimately, you'll get the opportunity to try and describe this record that you're seeking to a man who wears a black dress, carries a hammer, and used to wear a wig. You will get varying results. But you will get some results. Don't be afraid to appeal. The other thing, I put several, there's a few, like 25 or 30 requests that are in this book. They're already done. They're set and ready to go. If you're not a computer guy, there are some requests here that are done. If you'll follow the pattern that's laid out in the book, you'll make a request that is adequate, that complies with the law. I will tell you, when I use these requests, the only time the IRS refuses to produce something, when they will come back and they will write, your request isn't adequate. I know the request is adequate. There is no doubt in my mind. I have used this same request for over 10 years without change. So when they say it's not adequate, what I know is a bureaucrat's getting a raise. We've just done less work. They work. Appeal. Appeal. 802 appeals. Only 10,000 requests. You know the people in this room can generate 10,000 requests in a year? Easy. How many IRS offices are there? There's a bunch. There's a district office, right? There's a regional office. There's a service center. There's the national office. There's the compliance center. There's more centers than you know. Well, guess what? I went to the extra added effort of providing you with the Federal Register, Department of Treasury, IRS systems of records. It also has the addresses for all of the offices. Warning, there is a twist. They're reorganizing. Right? We've got a kinder, gentler, more confused, harder to find IRS. They haven't published the new addresses. As long as these are the published addresses, these addresses are adequate. If you don't get an answer, what do? Appeal. When you make a request, the IRS has 20 working days to respond. How many days is 20 working days? Well, it's about a calendar month. If there's a holiday in there, you're going to add another day. So you send the IRS a request. You can send that request certified mail if you wish. That way you know what day they got it. If it's important that we get the record, I'm going to tell you to send that request by certified mail. If we have time, I like to use the trusty certificate of mailing. It's a lot cheaper. Costs you about $50. IRS doesn't know you did it because you don't send it. The post office will certify that on a certain date you sent a piece of mail addressed to a particular IRS office. You can presume with reasonable safety that they'll get that in 3 to 5 days. You can start your 20-day countdown from there. If the IRS does not respond within the statutory 20-day period, there is a little doctrine that Congress put together for you. It's one of the few things Congress has probably done that was a nice thing. It's called constructive exhaustion. They declare that you've exhausted your appeal. So if the IRS doesn't write back in 20 days, where are we going? See the man in the black dress, carrying the hammer, wearing the wig. Go to court. You don't have to appeal. Now, what I like to do, and I'll recommend that you do the same thing because I want to be sure that I'm getting all the government I'm paying for, go ahead and file the appeal. Why not? Your appeal says, they didn't write me back. 20 days is up. They said nothing. Yes, you're in court at the same time. How many days does the IRS have to respond to an appeal? 20 days. 20 working days. It's going to be about a calendar month. How long does the IRS have to respond to the lawsuit? 30 days. The clerk of the court will change your summons and mark it 60. I heard somebody say 60. If you're really bright and you have a copy of the Freedom of Information Act with you, You can show the clerk where it's 30 days, and most of them will change their decision and mark the summons back to 30 days. Even if you get 30 days, what's the government going to do? They're going to ask for more time. They're going to want at least 30 more days. If the clerk makes it 60 days on your summons, now they come in with 30 more days. It's 90 days. How many days did you need to exhaust your appeal? 20 working days. Appeal exhausted. So they don't have any grounds to come in and say you didn't exhaust your administrative remedy. And don't forget, when you do this work, you are ensuring certain IRS personnel have a job for the future. I've seen what you do. I've watched the numbers go up in the different districts during the year. You know, it starts out with some kind of code. Usually it's like 1999-101, something like that. You know, I've seen it go into the thousands. In a couple of offices, I've seen it go to 10,000 in a year now. So you're doing your job. You're getting out there and you're doing the work. I want to point out a few systems of records that might be of interest to you. Yeah, so we're back to what do you want to know? You've got an IRS agent who's, shall we say, looking up your skirt, and you don't like it. You might want to find out what kind of training he's had. Guess what? Inquiring minds want to know. You can do a Freedom of Information Act request, and you can ask for the training records under a couple of different systems. There are several, really, but I'll just point a couple of them out. I'll give them to you by number. It's 26.008 and more light. 38.001. Those are training records. There are some systems, those of you who may think you're aliens, there's some systems of records that have information about resident aliens, non-resident aliens. You can inquire into those. I'll give you some sites if any of you are using that particular position. 49.001, 002, 49.007, and 49.008. There's one in particular that I want to talk to you about, and I know that there's going to be another speaker who's going to talk about that, and that's 46.002, and that's on page 56,825. That's called the Case Management Time Reporting System for the Criminal Investigation Division. And I encourage you, if you have an inquiring mind and you would like to know, this system of records has information on subjects and potential subjects of criminal investigations, including special agents, United States District Court judges, and United States attorneys. Inquiring minds want to know. You've got a district court judge that's maybe doing a good job in your area. Maybe you want to just send him a letter and say, Judge, you know, the IRS is keeping score. They're keeping score on you, and you probably didn't know it. You got a judge that's a problem? Maybe you want to inquire and see if there's something going on. Now, Bill Benson talked to you about getting into the systems of records with respect to, not systems of records, but getting the judge's financial statements and things. Same kind of stuff. You can use the Freedom of Information Act for all kinds of things. It applies to all of the government agencies that are executive class. It does not apply to Congress, and it does not apply to the judiciary. But anything under your good president, this act applies to. I've been signaled I'm kind of running out of time, so I want to touch on a couple other things real quick. Last year, we did a whole bunch of work, and this is really exciting. Some of you are going to be real pumped up about it, maybe as pumped up as I am. We've managed to produce a mostly unredacted, unsanitized Document 6209. This is the ADP IDRS handbook. This is the decoding manual. This is the one that helps you get through your individual master file. You know, that piece of garbage that you can't read? This is the book that they use to read it. They tried to keep us from being able to read it. They tried to mark out the information about criminal investigations. They tried to mark out the information about classification of illegal tax protesters. Of course, you all know they can't do that anymore. Congress said, That's being converted to the non-filer program, for those of you who want to know. If you ever need to know, it's a new system of records you can inquire into. We produced this book. I probably have, I think, 10 more of them available over at the table. And along that line, Dave Wellington and I, don't see Dave in the room. I was going to point him out to you. Dave and I are going to be doing a program tomorrow, all-day seminar. We're going to cover a whole bunch of stuff. Our program's entitled Winning Against the IRS. And Dave, over at the table that I'm working with, has just produced a new book. This is really exciting. This is Enforcing Your Social Security Number Privacy Rights. And he's worked his way through the California Constitution and the California statutes with respect to protecting the disclosure of your Social Security number to government agencies who are taking it for improper purposes, like the Driver's License Bureau. And Dave, we have the religious argument, right? We have the mark of the beast argument. But Dave's taken it a step further, and he's moved it out to where he's also looking at it from a constitutional privacy right, because California's Constitution, California's statutes make a unique exception there. So I encourage you to go over and take a look at that. And I look forward to seeing you all tomorrow. And I have kind of a parting thought for you. When I think of the IRS, I recently discovered something that it gives me a warm, fuzzy feeling, and I call it my handy bird. And when the IRS gets in touch with me and they'd like me to come in and just have a personal visit, I start thinking that maybe they're number one with me. And then when they issue the summons, I get a little more excited about how much of number one they might really be with me. And then when they take my bank account, they're just more on my list. But it's when they get around to taking my stuff that I really get irritated with them. I appreciate it very much, everybody. Thank you, and I look forward to visiting with you.